In the year 1386, in a small medieval town in northern France called Falaise, something happened that still defies logic, reason, and modern law. It was not a war. It was not a plague. It was not a religious uprising. It was a trial, a formal, public, legally recorded trial. And the defendant was a pig, not a metaphor, not a symbol, a real, living animal. This is the story of one of the most absurd judicial processes in human history, where an animal was arrested, imprisoned, tried in court, sentenced, and publicly executed, as if it were a human criminal. And this case was not an exception. It was part of a system. A child is found dead. The events began quietly, almost invisibly, as many tragedies do. In the outskirts of Falaise, near a modest household, a 3-month-old infant was found dead in his cradle. His body showed severe bite marks. The cause of death was brutal and undeniable. A domestic sow, a pig, had entered the room where the child slept and attacked him, causing fatal injuries. Today, this would be classified as a tragic accident involving an animal. In 1386, it was classified as murder, and murder demanded justice, the arrest. The pig was not killed immediately. Instead, something far stranger occurred. The animal was formally arrested. Witnesses recorded that the sow was seized by local authorities, removed from the household, and placed under custody, just like a human suspect. She was confined and guarded, not because she was dangerous, but because she was accused. Why put an animal on trial? To modern minds, this seems insane. But in medieval Europe, animals were not viewed as morally neutral beings. They were believed to be capable of moral agency, influenced by demonic forces, subject to divine law, responsible for their actions. Animals could sin, and if they could sin, they could be judged. This belief was not fringe. It was institutionalized. Between the 13th and 18th centuries, hundreds of animals were tried across Europe. Pigs, rats, horses, bulls, dogs, insects. Some were acquitted, some were excommunicated, many were executed. The court of Falaise. The trial took place in a secular court, not an improvised mob gathering. There was a judge, court officials, legal records, witnesses, a formal charge. The pig was accused of having maliciously and feloniously killed and devoured a human infant. The language of the indictment treated the animal exactly as a person. She was not described as a beast. She was described as a criminal entity. The defense, or lack of it. In many animal trials, defendants were provided with legal counsel. Yes, lawyers were sometimes appointed to represent animals. Insect trials, for example, often included arguments about territory rights and divine purpose. But in the case of Falaise, the evidence was overwhelming. Witnesses testified. The wounds matched the animal's teeth. The pig was found at the scene. There was no question of guilt, only of punishment. The verdict. The court found the pig guilty of homicide, not symbolic guilt, legal guilt. The sentence was death by public execution. But the execution was not to be simple. It was to be didactic. A message. The costume of shame. Before the execution, the pig was subjected to a ritual designed to mirror human punishment. She was dressed in human clothing. Sources describe garments resembling a man's tunic, gloves placed on her hooves, a mask or altered appearance. This was intentional. The goal was to show the public that the animal was being punished as a moral offender, not as livestock. She was being made an example. The execution. The execution took place in the town square. A crowd gathered. Men, women, and children watched. The pig was mutilated first to mirror the injuries inflicted on the child. Then she was hanged. Her body was left on display. Justice, according to medieval law, had been served. Why this mattered? This was not done out of cruelty alone. It was done out of belief. The belief that the universe was governed by moral order. That chaos must be punished. That even animals could disrupt divine harmony. Executing the pig was believed to restore balance. But here's the disturbing part. The mother pig had piglets. They were present during the attack. They were suspected of complicity. And yet, they were acquitted. Why? Because they were young. And the court ruled they could not distinguish right from wrong. Even in this madness, the law still debated intent. A system, not an anomaly. The trial of the pig of Falaise is one of the best documented cases. But it was not unique. In France, animals were routinely tried for killing children, destroying crops, spreading disease. In Switzerland, beetles were summoned to court. In Italy, roosters were executed for laying eggs, considered unnatural and demonic. In Germany, rats were formally warned to leave towns. This was not superstition. It was legal procedure, a mirror to human fear. These trials reveal something unsettling. They were not about animals. They were about human fear. Fear of chaos. Fear of divine punishment. Fear of a world without control. By putting animals on trial, society projected guilt onto something tangible, something punishable. The execution of the pig of Falaise may sound like a grotesque anomaly. It was not. It was part of a structured legal phenomenon that spanned centuries, countries, and legal traditions. Animals were not punished randomly. They were prosecuted. And the logic behind these trials was disturbingly consistent. Two types of animal trials. Medieval Europe recognized two distinct judicial categories for animals. Secular trials, ecclesiastical trials. Each followed different rules. Each revealed a different fear. Secular courts, when animals committed crimes. Secular courts dealt with animals accused of acts against humans or property. These included killing or injuring people, destroying crops, damaging buildings, threatening public order. Pigs were the most frequent defendants. Why? Because pigs lived among humans. They roamed freely through streets and homes. They were intelligent, strong, and unpredictable. When a pig killed a child, the law did not see an accident. It saw a breach of social order, and breaches required punishment. Legal procedure, not mob violence. These trials followed established procedure. Formal indictments, witness testimony, judges trained in Roman and customary law, written verdicts. Execution methods mirrored human punishments. Hanging, burning, beheading, burial alive. Animals were sometimes imprisoned before trial. Feeding and guarding them cost money. These expenses were recorded. Justice was bureaucratic, even when the defendant had 4 legs. Ecclesiastical courts, when animals sinned against God. Church courts handled a different kind of defendant. Not pigs, but insects, locusts, weevils, beetles, rats. These animals were accused of destroying crops, causing famine, acting as instruments of Satan. The church did not execute insects. It excommunicated them, the exorcism of pests. In these cases, animals were summoned to court, a given legal notice, assigned defense attorneys. Yes, insects had lawyers. These lawyers argued that God created animals for a purpose. Insects had a right to sustenance. Humans had invaded their territory. In some cases, courts ordered insects to leave a region within a fixed deadline. If they did not comply, they were formally cursed. A famous case, the rats of Autun. In the early 1500s, the town of Autun, France, placed rats on trial for destroying barley fields. A lawyer named Bartholomew Chassonneur defended them. His argument became legendary. He claimed the rats could not appear in court because the journey was dangerous. Cats along the route threatened their safety. Therefore, the summons was invalid. The court agreed. The case was postponed. Justice had been delayed. By cats. Why take this seriously? To medieval minds, this was not ridiculous. It was rational. Animals were part of God's creation. If they caused harm, it must be addressed within God's legal framework. Ignoring the problem would invite divine punishment. Theological justification. Church scholars argued animals could be instruments of Satan. Disorder signaled spiritual imbalance. Legal ritual restored cosmic harmony. Trials were not about deterrence. They were about appeasing God. By formally condemning animals, society showed obedience to divine law. The psychology of control. These trials reveal a deeper truth. Medieval society lived under constant threat. Famine, disease, a war, death. Science offered no explanations. Medicine failed. Religion filled the gap. Legal rituals created the illusion of control. If something could be named, judged, and punished, then chaos could be managed. When animals were acquitted, not all animals were convicted. Some were acquitted due to a lack of evidence, youth or incapacity, collective responsibility being unclear. This mattered because it showed that courts were not pretending. They believed they were administering real justice. The role of public spectacle. Executions were public. They were meant to be seen. They taught moral lessons. They reinforced authority. They reassured the population that order still existed, even when reality suggested otherwise. The gradual decline. By the 17th century, animal trials became less common. Why? rise of scientific thinking, shift in legal philosophy, changing views of animal cognition. Animals were slowly reclassified, not as moral agents, but as property. The law stopped asking whether animals were evil. It started asking whether humans were negligent. But the legacy remains. The trial of the pig of Falaise is still cited in legal history, not as a joke, but as a warning. It shows what happens when law serves fear instead of reason, when symbolism replaces understanding, when punishment becomes ritual. By now, the trial of the pig of Falaise no longer feels like an isolated madness. It feels like a symptom, a reflection of something deeply human, because these trials were never really about animals. They were about meaning, the symbolic function of punishment. In medieval justice, punishment served a different purpose than it does today. It was not focused on rehabilitation, deterrence, social reintegration. Instead, punishment was symbolic. It was a performance meant to restore order in a universe believed to be governed by divine law. Every crime was a rupture. Every sentence was a ritual to repair it. Why the animal had to die? When a pig killed a child, the loss was unbearable. There was no explanation, no science, no concept of accident. Something had gone terribly wrong in the moral structure of reality. Killing the animal did not bring the child back, but it created closure, a visible ending, a sense that justice had spoken, the need for a culprit. Humans have always struggled with random tragedy. We seek causes. We demand responsibility. When no human culprit exists, society looks elsewhere. To foreigners, to heretics, to witches, to animals. The powerless become convenient carriers of blame. Animal trials and witch trials. The logic behind animal trials mirrors that of witch hunts. Both relied on confession without comprehension, symbolic guilt, fear-driven logic, public spectacle. Both emerged in societies overwhelmed by uncertainty. Both collapsed when rational explanation replaced superstition, the illusion of moral order. These trials reassured people that evil could be identified, justice was impartial, God was watching. Even when nature was chaotic, the law pretended it was not. This illusion was comforting and dangerous. When law becomes theater, once punishment becomes symbolic, justice becomes theater. The outcome matters less than the performance. The execution of the pig was not meant to stop future attacks. It was meant to be seen, to be remembered, to send a message. The cost of this logic. When law prioritizes symbolism over truth, innocent beings suffer. Animals could not defend themselves. They could not explain intent. They could not understand guilt. Yet they were subjected to the full weight of human moral anxiety. The transition to modern thinking. As scientific understanding grew, explanations changed. Disease was no longer divine punishment. Natural disasters were no longer signs of sin. Animals were no longer moral actors. They became biological beings. The legal system adapted. Slowly, reluctantly, but the pattern did not disappear. We stopped putting animals on trial. But we did not stop searching for scapegoats. We still blame marginalized groups, outsiders, the voiceless. The structure remains. Only the defendants change. Why this story still matters. The trial of the pig of Falaise forces us to ask uncomfortable questions. Is justice about truth or about comfort? Do we punish to correct or to reassure ourselves? How often does fear guide our laws? These questions are not medieval. They are modern. The final image. Imagine the town square, the crowd, the silence before the execution, the certainty that order was being restored. Now imagine how little had actually changed. The child was still dead. Fear still existed. But justice had performed its role. The real absurdity. The most absurd part of this trial was not that an animal was executed. It was that everyone believed it made sense. By the late 17th century, animal trials had almost entirely disappeared from Europe. No more pigs in courtrooms. No more rats with lawyers. No more insects being excommunicated. History books often present this as progress, as evidence that reason defeated superstition. But that conclusion may be too comfortable. The end of animal trials, or just a change of target. What truly ended was not the impulse to judge the uncontrollable. What ended was the form it took. As science advanced, animals were reclassified from moral agents to biological entities to property under human responsibility. The law no longer asked, was the animal evil? It asked, who failed to control it? Responsibility shifted, but the need to assign blame remained. Modern law and ancient instincts. Today, when tragedy strikes, we still follow a familiar pattern. Identify a cause. Assign responsibility. Deliver punishment. This is not wrong, but it becomes dangerous when the process serves emotion more than truth. Public outrage still demands visible culprits. Media still amplifies fear. Law still performs reassurance. The stage has not disappeared. It has been modernized. The comfort of a verdict. A verdict creates closure. It tells society, the problem has been solved. But many problems are not solvable. They are tragic, random, meaningless, and that is deeply uncomfortable. So we convert chaos into guilt. The silent defendants. The animals on trial could not speak. They could not explain instinct. They could not argue biology. They absorbed human fear without resistance. Today, other silent defendants exist. Groups with less power, less voice, less protection. The mechanism is familiar. Only the language has changed. Why this story still goes viral. Centuries later, people still share the story of the executed pig. They laugh. They express disbelief. They call it stupid. But the story spreads because it feels unsettlingly close. Because it exposes something we prefer not to see. The dangerous idea of moral order. The medieval world believed the universe was morally structured. That every disaster had meaning. That every violation demanded punishment. When meaning disappears, fear grows. So meaning is created, even artificially, even violently. The pig of Falaise as a mirror. That animal did not understand the court, did not understand guilt, did not understand death. But humans did. And they chose ritual over understanding, certainty over doubt, punishment over explanation. Are we really different? We no longer dress animals in human clothes before execution. But we still stage justice. We still simplify complexity. We still demand endings. And we still struggle to accept that some events have no moral lesson. The final question. The most absurd trial in history forces us to confront one question. Do we seek justice? Or do we seek relief from fear? Because if history teaches us anything, is that law can become a mirror of anxiety. And when that happens, reason is the first thing put on trial. Final image. A medieval town square. A silent crowd. An animal condemned. A sense of order restored. For a moment. Closing line. The trial ended. The execution was carried out. The records were archived. But the instinct that created it never disappeared.